Here we are talking about defects and what's going to happen with the Strata Scheme Management Act. Now, some of you tonight may know about it, some may not know about it, some may not even care. But I guarantee you this, come July 1, you will all know about it. Just a little bit of history, thank you, just a little bit of history about how this Act has come about. 2015, the Department of Fair Trading through the Department of Finance decided that the developments that did not have to have homeowners warranty were getting away with defect issues. The consumers weren't protected enough. So in 2015, the Department of Finance passed an amendment to the Strata Scheme Management Act of 2015, they called it, which now requires developers to put forward a 2% bond for the security of the rectification of defects. In 2016, they passed the regulations, which gives some intent as to how this is to operate. And come what may, the department has said, come 1 July of 2017, any contract they'd entered into will be subject to this security bond. So the exposure now for developers is threefold. One under the contract, one possibly under the Home Building Act, under the Home Warranty section, and now you have the security bond as if you didn't have enough to deal with. Now, this Act and the regulations will apply to all buildings that don't require homeowners warranty. So that is any buildings, any development you do that's over 3 stories high, that's what this Act will apply to. Sorry? This is state only Act. Queensland and Western Australia and so forth, they're off scot-free at the moment. The Act basically says in Part 11, and I've tried to boil this down. This is actually a topic that we could spend an hour on, but we've only got 15, 20 minutes, so we'll cut through to the eye teeth of it. It's a 2% bond of the contract sum. So if we think we were going to do what we used to do in the old days when we used to fill in the council application forms and the fee down the bottom said estimate of works, and we would all sort of say, yeah, it's not worth that much because our fees were dependent on that. You're too young to remember that. That's gone because the department now has the authority to appoint a quantity surveyor to check your calcs. So if they're not happy with the estimate, they can appoint a quantity surveyor to check your numbers, which is really fun. The bond is to be paid to the Department of Fair Trading. It's not cash. It's either an insurance bond or a security bond. And the line there where it says it's to be paid prior to the commencement of construction is not correct. That's the obvious error in the lecture tonight, the talk tonight. It's to be paid prior to your release of the occupation certificate. So you can start building, but you've got to put that 2% into the department prior to that occupation certificate. So you've got a bit of time. And the bond is to be held for 3 years maximum. That's all that the Act allows for, 3 years. So, how is this going to operate? What the department, in their wisdom, have decided is that they're going to have inspectors, building inspectors, go through and look at your buildings, look at our buildings. And they are to be appointed within 12 months after the date of completion. And they're taking completion as being the date of the occupation certificate. So within 12 months you have to appoint an inspector. This inspector is to do 2 reports. Within 15 months of completing, in other words 1.5 years after completing, he has to do what's called an interim report. That's his first report. And he must finish that between month 15 and month 18. We'll talk a little bit about that. After that, he then goes through at month 21 and does what's called the final report. and this report will tidy up what was in the first one. So there's two reports. Now, the inspector is not just anybody you like. The inspector is going to be someone from one of those organisations. Now, those organisations are actually listed in the regulations which Mr. Pierre Saab, who is building expert lawyer extraordinaire, knows all about. They're listed in there. And those organisations are now formulating panels, strata inspection panels. I'm on the MBA panel for the establishment of the inspectors for the MBA regime. Now, the process is the developer selects an inspector. The developer then sends that name to the Owners Corp. If the Owners Corp don't like that name, or they know that guy, no, he doesn't do inspections properly. He's too loose, he doesn't pick everything up. They can reject that. They can say, no, we don't want that inspector. Rejected, Mr. Developer. Then what happens is the developer and the Owners Corp apply to the Department of Fair Trading, and they will appoint an inspector to carry out these inspections from a panel. The good part is the developer is to pay the inspector's fees. Okay? All right, not paying enough yet? And the second part is that the 2% is not for the inspector's fees. So you're really going to start racking this up. So if you're doing a $10 million development, 2%, $200,000 plus fees of the inspectors. 200? Now, when you lodge for an OC, or when you lodge the bond, the department now requires the developers to provide this documentation with it. Now, with the DFT, we're working through how this is going to happen. I think we're going to be setting up an electronic portal, or the DFT will be setting up an electronic portal that the developer can lodge all these documents. But just have a look at the list of some of the material you're going to have to collate now. Apart from any documents relating to the price, the building contract, the specification, the written warranties, any schedule of non-conforming works, as-built drawings, yeah? We get as-built drawings? No, that's not going to happen. Schedule of approved samples, DA consents. Now, O is my favourite, the alternate solutions for fire engineering reports. I don't know how that's going to happen. That's going to be hard work. But that's what's expected to be lodged for you to be able to get your bond, like to get your stamp that you've lodged your bond. If you can't get your bond, you can't get your OC. That's how they've geared it. Now, let's go back to the reports. The reports, the interim report, is going to take a form as prescribed in the regulations. Now, I'll give you a little bit of history behind this act. The department wanted this rushed through. They said, we've got to do something about defects, it's all far too much, it's costing all too much, homeowners' warranties taking care of all the simple stuff, but we have nothing to protect other people who aren't subject to homeowners' warranty. So they will rush through this legislation, and the department said the form of the report is going to take in a form that's approved by the Secretary, and that's the Secretary of the DFT. What the DFT did in 2015, they agitated the Australian standards to say, look, we want you guys to come up with a standard now for the inspection of strata buildings. You've got one for Class 1 buildings, but you don't have one for strata. So the Strata Committee for the Australian Standards has been working away for the last 2.5 years, and for those of you who may know, the draft of the standard went out to public comment in January this year, and over 250 comments were received, basically saying the standard was rubbish. So it's gone back to the committee, and I'm on that committee as well, so we're looking at that one to see how we can make it work. The reason that's important is because the DFT, who've been landed this to make it work, are not sure how it's going to work. They're hoping the new Australian standard will be the format that they can just adopt and say the form of the report will be the one in the Australian standard. The DFT are currently thinking and just playing their cards close to the chest. They're saying, if that's not acceptable, if we don't like that, the DFT are actually going to produce their own report format, which really could be interesting, to say the least. The only things to identify in this interim report is what a defect is, and the second thing is, if reasonably practical, identify the cause of the defect. This interim report for developers is very, very important because all the defects that are claimable or not live and die by the interim report, the first report. The second report, the final one, only goes back and simply statuses the work under the interim report. So the interim report's always going to be the one, if there's going to be a defect claim, it's going to be in this one. So that's the one that the inspectors are going to be really concerned about. The final report is interesting. It's in the form to be approved by the Secretary again, which they're hoping it's the standard, the Australian standard. And to identify the defective work, to identify any defective work in making good work. And the third one is a scope of rectification of how the defect should be rectified if it's not been rectified. This is a problem. I can tell you from consultants' point of view, and Michael's here tonight, you could talk to him afterwards. Some of these inspections that you go through, they're visual. And we have often the problem of we walk into a bathroom, you can't see the threshold bar at the bathroom. AS 3740 says you should be able to see it. If you don't see it, is it a defect? It's more than likely there, but you've got to bust a few things up or scratch things up to find it. The Australian standard basically says that it's only going to be a visual standard, just a visual look. And the consultants are trying to come to grips, how do we as consultants report things to developers when even ourselves we're not quite sure if it's a defect or not because we don't have the ability to open things up. So that is a real issue we're trying to come to grips with at the moment. Serious issue. Now, the definition of defective building work, this is residential again, mind you, is effectively anything that breaches the Home Building Act. Okay? Anything that breaches the Home Building Act will be considered a defect. The problem we're also coming to grips with is we might see a defect in a building, but it could be a defect due to a third-party impact. In other words, somebody knocking a wall or something, and you get defect. You've had consultants go through at times saying, ding in wall or ding on wall or something like that. Well, that's because people are moving their furniture and have dinged it. So the real issue is going to be now trying to distill what is a builder's defect as opposed to what is a defect, for want of another words, wear and tear, lack of maintenance, or just third party being involved. This will be the skill of the inspector who you select to try and work it out so you don't end up with a report, and I'm sure you've all seen them, those shopping list report that have things like 250 defects for a 2-bedroom unit, and you think to yourself, how is that possible? 250 defects. So, yeah, that's the skill. Now, the cost of the inspector, as I said, is going to be borne by the developer. The DFT is possibly looking at fixing fees to try and do it on a scale basis, but that's not going to happen because we don't know, inspectors don't know what's going to happen, they don't know what they're going to find, and there's no set rate for it. How do you set the rate for this work? But the one thing the inspectors know is the developers will pay. It's according to the DFT. Now, this is an interesting one for those of you who do end up in a tribunal or court due to defects. The inspector's report can be used in the proceedings before the tribunal or court. But there's a few issues that still remain with that as the evidence and whether it's actually prepared properly or not. But that's an issue that they're trying to get around. So, that's setting the scene for what you're up for any contract entered into after 1st of July 2017. 2 months away, 5 weeks away, 6 weeks away. This really won't happen probably till the end of, you've probably got a year and a half yet to gear up for this. How are you going to do it? I know other developers and builders we've been talking, some of them are going to throw this back onto the builders and say, hey, just incorporate this into the contract, please. But it is a developer's requirement, this is not a builder's requirement. And the interesting thing, if you notice that most of the contracts have, 12 months defects liability period, developers now may want to start thinking about making defects liability period 24 months to start covering these events at 12-month, 15-month, 18-month, 21-month and 24 months. So you may want to think about that. I'm not sure, but I'm sure Pierre and other lawyers in the room will guide you about that. There was over 260 comments to the proposed standard that the DFT is looking at adopting. The major contributors were those 4 people. The current document is going through its final edits. Yeah, we're doing our final edits now, and we had a meeting in May where the committee met, and we basically reformatted the standard. We got rid of a lot of definitions and issues, and we've made it even simpler now. Hopefully that works. We did have the strata committee. The strata community were represented at that, and they wanted everything and anything in there. They wanted everything, lock, stock and barrel. But a few of the consultants around the table, the MBA, HIA, we all pulled back and said, no, you're not going to get that. It's not appropriate. Of course, remember the MBA and the HIA are really builders turned developers or other developers starting up, so we're trying to protect those interests as well. Assuming the amendments are accepted by the subcommittee, the Australian standard will hit probably around July to September, somewhere in there. And when the DFT have a look at it, they may adopt it. They may actually say, this is what we want. If not, they'll be running their own version of it. Now, some of the challenges in this, in formulating the Australian standard to try and accompany all this, is that it had to be a national standard, it had to have minimum requirements, it had to be a standard that could be used across Australia but adapted very easily for New South Wales. So New South Wales had a massive punch-up with Queensland, nothing new. And we got an appendix in there called Appendix E, which is New South Wales, which addresses the Act and the regulations for how to do the reports. Now, these are the major issues, the definitions of defects, identification of what a building fault is, because that's extremely important when you do these inspection reports. Now, when your inspector does these inspection reports, this is a whole topic on its own. We're developing that up because, as we said, you've got to be able to identify between wear and tear, building maintenance, and so forth. These are some of the challenges you're going to have now. You're going to think about spreading the risk and what the cost is of this to you. This is going to be interesting because you've got to remember this is a third layer of potential litigation that you have. Now, we've been talking to some people, some builders and developers, and they've taken the attitude, you know what, this is all getting too hard. We'll get the bond together, or we'll get the cash together, and when at the end of the job, we'll just walk away from it. They can have the 200,000 or the 100,000 or whatever, or the 300, and we'll just build that into the cost. Just think about this. What you've done, though, is that you've given the Owners Corp $300,000 as a fighting fund to all of a sudden engage some lawyer to start up some new action, because you've now have 3 parallel causes of litigation in your hands. You have one's under the contract, you have one under the Home Building Act, and the third one is now under this. So you've got to think really carefully. To show you how rushed the legislation is, they didn't even think about it. In the Act, they talk about the final report. Nowhere in the Act does it link the cost of the final report to the bond. The intent was that the $200,000 is to be provided, the final report goes through, the QS was supposed to go through and say, okay, all those items are not done, not finished, or they haven't been done. They value those items, and let's assume the bond's 200,000, the items are 100,000. They say, okay, we'll keep 100,000, we'll give 100,000 back to the developer. Okay? That's not even in the legislation. They rushed it so fast they didn't even put that mechanism in. So now they're trying to work it out through the regulations. But the important part that everyone's starting to think about is what if you've got a $300,000 bond and the defects, once the quantity surveyor gets a hold of it, and he'll price it, he prices the defects at $600,000. There's a shortfall, and perhaps one night Pierre can talk to us about that, what the lawyers are going to do about that. But there's a potential there for a litigation arena, a new litigation area. The inspectors are going to be petrified because in the interim report, if they don't identify a defect in the interim report, that can't be raised in the final report. So they only have one shot at it in the interim. Sorry? Yeah, they're going to... That's exactly right. That's what we're afraid. They're going to put everything. Now, when you think about it, this is everything at month 15, which is 3 months after defects liability period. Building looks pretty good then. Should look pretty good. So what are they going to find? But they'll find things. They'll find things because one of the guys on the committee, who was a lawyer, a Sydney lawyer, strata lawyer, made it no bones that he said, if these inspectors stuff up, make no doubt about it, we've got a statement of claim ready to go to sue these inspectors. So these inspectors are going to be looking at things very carefully. Thank you. That's a 15 to 20 minute summary of what's happening in the industry. Thank you.